The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome to the afternoon docket. I will ask the clerk of the Kansas Appellate Courts, Mr. Doug Shima, to please call this first case on the docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Friday, September 17th, 2021 consists of two cases. First case to be heard on the docket is appeal number 121220, State of Kansas versus Monroe, Eugene, Reed-Chism, Sedgwick County, briefs both sides. The second case immediately following will be appeal number 123708 in the matter of Mitchel B. Christians, matter and attorney discipline. Briefs both sides. Your Honor, the appellant in State versus Reed-Chism, 121220 has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Good afternoon, Your Honor. My name is Randall Hodgkinson. I'm appearing this afternoon on behalf of Monroe Reed-Chism, and I'm ready for argument.
Thank you. May it please the court. Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Before we begin our arguments, I do want to note that Justice Melissa Standridge is recused on this first case on our docket this afternoon. We're very honored to have sitting in her place Judge Stephen Hill, a judge of the Kansas Court of Appeals. Judge Hill has served on that court since 2003. And before that, he served as a district court judge for 22 years in Kansas's 6th Judicial District. Cumulatively, that means that Judge Hill has served as a Kansas judge for about 40 years. I believe that makes him the longest sitting law-trained judge in Kansas history. And even if we're wrong with that, he's got to be right there at the top. So Judge Hill, we applaud your historic service as a public servant. And we thank you for those many years of service and also, especially today, for taking time to help us resolve this appeal.
Thank you, Chief. It's an honor to be here and I'm ready to proceed.
With that, Mr. Hodgkinson, you may begin your argument.
Thank you, Chief Justice. I would just note quickly that this is a direct appeal from a conviction for aggravated battery out of Sedgwick County. The allegations in this case were that the victim was shot after an altercation on the street in a location in Wichita. An interesting fact about this case is that the victim actually testified that it was not my client that was the shooter, but my client was identified by another person on the scene. And so the jury convicted my client of aggravated battery, and my client received a prison sentence of 13 months in prison. There were two issues raised in this case, Your Honor, and they were sort of related because they have to do with whether the state proved Mr. Reed-Chism's culpable mental state and or the related issue of whether a lesser included offense instruction should have been given in this case. Again, my client was convicted of knowingly causing bodily harm with a deadly weapon, a gun. On appeal, we argued that the district court should have also given a lesser included offense instruction for recklessly causing bodily harm with a gun. The Court of Appeals in this case, in our opinion, respectfully, misapplied the standard of review in this for this issue because the Court of Appeals agreed that reckless aggravated battery is a lesser, as a legal matter, it's legally appropriate, but they found it was factually inappropriate, citing all of the evidence that would support a finding of intentional knowing conduct in this case. Your Honor, the standard review when we're dealing with instructions should be in a light most favorable to the party requesting, for example, on appeal, the instruction.
Counsel, could I interrupt you there and ask you what evidence there was in this record that shows your client acted recklessly?
Sure. And it's related, Your Honor, to I mean, the Court of Appeals cited a lot of different things, like that there was an altercation and that the victim in this case was saying, using vulgar language and saying, shoot me, and that in fact, the victim was shot. And those are all evidence of knowing conduct. And we didn't dispute that fact that from such evidence, you could infer knowing conduct in a light most favorable to the state. The question, and where I think the Court of Appeals went wrong, is the idea that could that evidence also support an inference of reckless conduct? And our opinion is absolutely. I mean, we have to imagine, okay, you have to imagine in your mind the circumstances of, if you believe in such a thing, a reckless aggravated battery with a firearm.
Let me stop you one more time if I could. Had the defendant asked for a lesser included instruction for reckless, and that was denied by the trial court and appealed, what would be our standard of review then?
The standard of review is the same, Your Honor, as far as legal appropriateness and factual appropriateness. For legal appropriateness, it's a de novo review. And for factual appropriateness, it's viewed in a light most favorable to the party seeking the instruction, viewing that record in a light most favorable to that party. Now, the reversal standard might change, whether if I didn't, and in fact, I admitted in our brief that I'm dealing with a clear error reversal standard, but the standard of review doesn't change. And that's our whole point, Your Honor, is that that some circumstances, and we think these circumstances, allow for an inference of either knowing conduct or reckless conduct. The Court of Appeals in this case said that there was evidence in this case that that gun was pointed at the victim in this case, and that, well, every time somebody commits a knowing aggravated battery with a deadly weapon, they necessarily point the gun at the person. And I think that's probably true. The idea that if you knowingly shoot somebody, you point a gun at them. I think that's probably true. The fallacy, the problem with the Court of Appeals logic is the converse isn't always true. It is that sometimes a person might be shot, therefore the gun was necessarily pointed at them, but it was accidental or reckless. If you took the Court of Appeals logic to its extreme, there could be no such thing as an accidental or reckless shooting. And that's not reality. We know that thousands of people, sadly, are recklessly or accidentally shot each year and injured or killed. So I don't think that's what the court, the court, I think, just sort of missed that point, that the converse isn't necessarily true. And so the question is, do the circumstances in this case, viewed in a light most favorable to my client, also support reckless conduct? And the answer is yes. Again, if we just imagine in your mind, if you believe that there could be reckless aggravated battery with a deadly weapon, and I hope we do, what would it look like? And would the facts of this case be consistent with that? And the answer, I think, is yes.
Is that true in every aggravated battery causing bodily harm with a gun, with a firearm? Is that, explain to me, under your scenario, it seems to me that you would always give a reckless instruction. Is that right?
Well, not necessarily, Your Honor. I certainly.
What scenario wouldn't you? I mean,
Yeah.
Basically what you're arguing is when someone fires a weapon at someone, it could be they didn't mean to do, they could have done it in a reckless fashion and didn't aim or did something. And how, in what instance would it not be given your theory?
Yeah. And so, Your Honor, again, I could think of a scenario, something like O'Rear, State v. O'Rear, where this court said that there are circumstances where all of the evidence is that somebody acted intentionally.
All right, there was evidence in O'Rear that that's what he intended to do.
That's right.
Right.
If you have direct evidence of that and no contrary evidence or something like that. So from just a factual scenario, from just reviewing the record from the factual scenario, I would admit there probably are some circumstances like O'Rear where you would say there's no evidence of recklessness. Now there's a separate statutory argument that the Court of Appeals is dealing with, of sort of whether, because of statutory changes now, that's different. But from just a pure, I think your question is, are there any actual factual circumstances? And I would say, yeah, there might be, but this case isn't one of those, particularly given the paucity of evidence of sort of intent in this case. That Could the jury have inferred knowing conduct? Yeah, we didn't raise a sufficiency issue in this case with regard to the culpable mental state. But could those same facts, viewed in a light most favorable to my client, also allow for an inference of reckless conduct? Our argument is yes, and therefore the instruction in this case would have been factually appropriate. And that's where the Court of Appeals erred.
Counsel, it seems though that argument that you just illustrated for us hurts you if we get to the last stage on harmless error or clear error analysis. What was the theory of defense here? Is identity, correct?
It was misidentification, yes.
Right. So how do you demonstrate, even if we were to embrace your argument on factual appropriateness, how do we ever get to clear error?
Sure. And Your Honor, also I would piggyback on your question a little bit to say that's another error that the Court of Appeals made in this case by even sort of citing that back with regard to factual appropriateness. Because this court has made it clear that even I can have contrary defenses, right? I can say misidentification, but even if it was me, I had a lesser culpable mental state. So the fact that I may have contradictory defenses like that isn't a legal problem. So the fact that my main defense in this case was, not surprisingly, given the victim's testimony, it wasn't me. But that doesn't change the circumstances. You still have to do the same analysis with regard to the culpable mental state or the lesser included offense that you would if I had, not made that same defense. It doesn't change that analysis at all. And I would suggest it really doesn't change the harmless error, the clear error standard for harmlessness in this case at all either. You still will review the record the same way. What defense I put on doesn't change the evidence that's in the record. And so you would make the same analysis. And so you would have to evaluate the record as we put it, which we think is, there is some evidence of knowing conduct. There is some evidence of reckless conduct that, a jury could equally have found had they been given that option. Is there a real possibility, particularly given the paucity of evidence regarding culpable mental state, that they could have gone that way if they given that option? And our position is yes. My time's running out, so I did want to spend just a minute on the second issue here, which is a prosecutorial error issue. And Your Honor, I think it's interesting. It's an interesting example for me here at the law school, because, we teach legal writing, and part of things that I work with students on is on legal writing, the importance of active language versus, active language versus passive language. And we do that, thinking about how it's important because it makes better writing in general. But it turns out sometimes that actually active voice is different than passive voice. It has a different meaning. It's not just weaker language, it's different. And our position is that's in this case. So the prosecutor in this case said, my client pointed the gun at the victim. I'm sorry, the prosecutor in this said that the witness testified that my client pointed the gun at the victim.
Now, I'm going to ask you, is that exactly what the witness said? Didn't she say that, didn't the prosecutor say the witness saw the defendant point the gun at the victim?
Yeah, yes.
She didn't say the witness said she saw the witness point the, the prosecutor didn't say the witness said she saw the defendant point the gun at the victim.
She said that she saw the defendant point the gun at our victim. That's record 10, page 95.
Right.
That's a direct assertion of what that testimony was.
The prosecutor said that Gandy, the witness, saw the defendant point the gun at the victim. That's what the prosecutor said, correct?
Yes.
But the prosecutor did not say Gandy said the victim pointed the gun at the victim. Is there a difference?
Yeah, I guess, Your Honor, maybe I don't think there's a difference. I mean, it's either the prosecutor saying that's what she said, or it's the prosecutor's personal statement of what that witness said, and I'm not sure that's really different. It's our position that the prosecutor could have said in this case, for example, look, with all these facts, you can infer that the defendant pointed the gun at the victim. I think that would have been fair argument, but it is our position that the statement that the prosecutor made goes farther than that it's much more direct than that, and therefore crossed the line into misstatement of evidence. That's all I have for my opening presentation, Your Honor.
Are there other questions? Thank you, Mr. Hodgkinson. Mr. Gillette?
Thank you. May it please the court. I'll briefly address both issues that have been argued here today. First, regarding whether or not KSA 2152 the lesser included in statute required a giving of a reckless instruction here. And there were pointed questions to opposing counsel about what evidence was there in this record to indicate that the defendant acted recklessly. And my answer to that question is that there was none. As the Court of Appeals found very clearly in this case, none of the evidence suggested that the defendant acted in a reckless manner. All of the evidence showed that he acted either intentionally or knowingly. And so for that reason, and a lesser included instruction would not have been appropriate in this case. Had it been given, we would be here with the roles reversed, with the defendant arguing that, look, there was no evidence of reckless actions on my part, and had a jury convicted of that, then it would be a pass. The defendant would be acquitted, or his conviction would be reversed. So that would be my first argument. The second argument that I would say is that I think that both the younger courts and the Court of Appeals panel in this case got it right. Our statutes are pretty clear. The clear language of 2150-109 says that this inference, this evidentiary inference for criminal liability, that a defendant may be convicted of either the crime charged or a lesser included crime, tells us what is a lesser. And then we go on to 2150-202, subsection C, tells us that proof of a higher degree of culpability than that charged constitutes proof of the culpability charged. The operative word here being charged. The legislature clearly knows how to use charged or lesser included. They did so in 2150-109. The language is clear. This presumption only applies to the crime charged, as the lower courts have consistently held. So I think the defendant's argument fails for that reason as well. Finally, if this court were to disagree with either of those arguments, the defendant here cannot demonstrate clear error, because it would be his burden to firmly convince this court that the jury would have reached a different verdict but for that jury instruction error. And again, here, the eyewitness, Miss Gandy's testimony was clear. It was the only evidence in this case of the defendant's really of his actions and his intent. And I guess I would also take issue with the fact that opposing counsel claimed that there's a paucity of evidence for intent. The record in this case is fairly clear that this started as a nearly 15-minute argument with the defendant sitting in a car outside of a home. The argument escalates with the victim coming outside, and they continue to argue there with the defendant still in the car. Eventually, the defendant gets out of the car. I don't know how you get out of a car recklessly unless I'm not sure how that would possibly happen. Then he reaches back into the car and grabs a firearm. Again, this is clearly knowing or intentional conduct. And then the fight continues. We're nearly 30 minutes. It proceeds out into the street. And I think potentially most critically, the argument and taunting, the vulgarities continued until the victim was yelling, "Shoot me, shoot me."
Counsel.
Yeah.
In viewing the evidence in a light most favorable to the defendant, we are to assume that he knowingly pulled the trigger and knowingly aimed at the victim's leg to shoot him. Correct? You're saying viewing it in a light most favorable to the defense, those are the inferences that have to be drawn.
Can you clarify your question, Your Honor? I apologize.
Do you agree that we're looking at the evidence in the light most favorable to the defendant when we look at the instruction, whether the instruction is factually appropriate?
I do agree with that.
So from the evidence that's been submitted, must we then infer that he knowingly shot him in the leg?
I don't know that you have, I mean, if that is true, then
Well, if
then
we
there's no reason
can't,
for us to be here. He's guilty.
if we can infer that he was not aiming at the leg or didn't intend to shoot him at all, but just it was some kind of a wild shot when he was aiming at the tree, isn't that reckless?
Your inferences must be drawn from evidence in the record. It would be my answer to your question there. And here, there is no evidence of reckless conduct, of aiming at a tree and pulling the trigger. As I was getting to this escalated to the point where the victim was yelling, "Shoot me, motherfucker, shoot me." The defendant says, "Shoot you," and then a shot is fired. There's nothing reckless about that. I think it would also be fair to say that if we're to view the the evidence in the light most favorable to the defendant, as Justice Wall asked about, the defense here was identity. The defendant's claim was, "I wasn't there." If we were to view the evidence in the light most favorable to the defendant, that would be the light we would view the evidence in, and the jury clearly rejected that. So again, the defendant cannot demonstrate clear error with the verdict in this case. If there are no other questions on that issue, I'll briefly move on to the misconduct issue. Justice Wilson, I think you're kind of hitting the nail on the head there. The prosecutor in this case did not say the witness said she saw a defendant point a gun. The prosecutor's argument here was a reasonable inference. I guess I would also point out, again, prosecutors are given wide leeway to make arguments based on inferences that can be drawn from the evidence in the case. Here, I read the Court of Appeals opinion perhaps slightly different than opposing counsel, because they preface the factual scenarios that defendant claims or complains about to this court with the following quote: "More importantly, none of the evidence presented at Reed-Chism's trial supported that he acted recklessly. Based on the evidence presented, we know the following." So the Court of Appeals panel wasn't reviewing this in a vacuum. They weren't speculating as to random theories that could have existed, and that's important. Courts are to review the record in the case.
Speaking of the record and the evidence,
Yes.
is there any evidence in the record that the defendant, quote, pointed the gun at the victim, other than the evidence that the victim ended up getting shot?
I think the evidence, it is an inference that was argued, and I think it's based on primarily on two things. First of all, Ms. Gandy testified, and she was very clear that she saw the bullet travel from the gun. She saw the flash, and moments later, we have the victim in this case with a bullet hole in his leg.
Wouldn't it be an equally reasonable inference that the defendant was just wildly waving the gun around and it went off?
I don't think so, based on the length of this argument, the statements that were made, the demand from the victim, "Shoot me," the victim and the defendant saying, "Shoot you," and the gun going off. No, I would say no. So what the prosecutor was arguing was that inference. She was drawing that inferential step as part of her argument to the jury, and in doing so, that was appropriate argument. even if it were not, or if there was some kind of error with that argument, again, the standard here is that for reversal would require us to demonstrate that there's no reasonable possibility that any error resulted in the verdict. I think the record is clear here that this verdict was based on the evidence, not the argument. Particularly unique about this case is that the jury asked for a readback of all of Ms. Gandy's testimony, and they received it. I think that's pretty telling of what the jury relied upon to make their decision in this case. It wasn't the argument, it was the evidence. If there are no further questions, Judge
Yeah, I
Stevens,
guess I'll have one follow-up on the prosecutor's statement.
Sure.
Is there anything in the witness's testimony that would be untrue if in fact she did not see the defendant point the gun at the victim? In other words, for purposes of my question, just assume that the witness did not actually see the gun pointed at the victim. Everything else she said still could have been true, right?
I'm not sure, just because I'm not sure that that's the case.
Can you point to something that she said that would not be true if she didn't see the gun pointed at the victim?
I mean, I guess not, other than the fact that she said she heard one shot and she saw the bullet fly.
But why can you draw an inference as to where the gun was pointed? In fact, arguably that cuts the other way. If you're looking at the gun and you're so focused on the gun that you actually see the ignition of the powder and the muzzle flash, why is it a reasonable inference to conclude that, oh, she must have saw that it was pointed at the victim?
Because the victim was hit, and it was one shot, and the evidence in this case was that there was a single casing found in the street as well as a live round. So I think that also would bolster the fact that there is this one shot. It was a deliberate act, knowingly or intentionally done. I guess that would be the best way I could answer your question.
Well, counsel, didn't she say that she saw the victim bleeding and holding onto his leg or something like that?
Yes, with the makeshift tourniquet in the seconds after the shot was fired. Yeah. So with that, Your Honors, that concludes my presentation. I would respectfully ask that this court uphold the defendant's conviction in this case and reject the defendant's two arguments on appeal.
Thank you, Mr. Gillette.
Thank you.
Mr. Hodgkinson, you reserve 3 minutes.
Thank you, Your Honor. I had just 2 quick points. I mean, I'm reminded of the legion of cases that we would have that talk about how it's often difficult, for example, for the state to prove a defendant's intent or premeditation with direct evidence. And so it's quite frequent, quite common for the state to get to prove that intent or premeditation with circumstantial evidence. I guess all I'm asking you today is to apply the same rule when it's the defendant asking for that application of the standard of review to a determination of factual appropriateness. I think Justice Stegall, you have to think of this scenario where there is a reckless shooting, and would it necessarily look any different than the facts you have? There's nothing in the facts that you have that exclude the possibility of a reckless shooting in this case. It could be intentional, it could be reckless.
Let me follow up on that with the one piece of evidence that seems to me to cut most strongly against your argument, and that is the timing of the dialogue. Shoot me, you want me to shoot you, and then a shot. Doesn't that cut against a recklessness finding?
No, I don't think it excludes the possibility of a reckless finding. I mean, can the state argue that that's why they think it's knowing? I think that might be a fair argument. But is it also just consistent with an escalating sort of confrontation where, again, a person says, the victim in this case says, "Why don't you shoot me?" And maybe my client says, all right, it just sort of points the gun at him and the idea that I'm going to scare him and didn't intend to shoot, but then pulls the trigger. That would be conscious disregard of the risk. That's recklessness. I'm not a gun owner, Your Honor. I don't shoot guns. I've been told by people, you don't ever like point a gun at a person unless you need to. That's why, because it's risky. Just pointing a gun, even though you don't intend to do anything with it, it's risky just to point a gun at somebody. And so that's why I would say I don't think it excludes that possibility. It might be an argument, but it doesn't exclude the idea that the circumstances in this case and all the inferences from it could also support recklessness. The last point I wanted to make was just in response to my colleague's statutory argument, that the statute, as amended, I think it was in response to a rear, this idea that the court says that there are some cases where there are circumstances where it's only intentional and not reckless, and the state didn't like that result. So they got the legislature and successfully got the legislature to set up a legal fiction that if there's intentional or no evidence of intentional or knowing, that's evidence of recklessness. Here they're sort of asking this court, well, but we don't like it in this circumstance. We don't like that law in this circumstance. The idea that it turns on the fact that the statute says the word charged. Well, you know what? When a person is charged with a greater crime, they're also charged with all the lessers. So my client was charged with reckless aggravated battery in this case. So to the extent that you're doing that sufficiency analysis, there's no reason because of that word that the analysis wouldn't apply. We would ask you to apply this statute equally, not just favorably to the state. Thank you, Your Honor.
Are there any questions? Thank you, Mr. Hodgkinson, and thank you, Mr. Gillette, as well, for your arguments today. I'd also like to again thank Judge Hill for his participation in the arguments. He will be participating as the court discusses the outcome to be reached in this case and as the opinion and decision is written and filed. With that, we will take this appeal under advisement. We'll have a short pause in the proceedings now as Judge Hill, Mr. Hodgkinson, and Mr. Gillette leave us, and we bring in Justice Standridge and the attorneys on the next case on our docket.
Chief Justice Standridge and attorneys are in the meeting.
We might wait one moment for Justice Rosen, and then Mr. Shima, if you would call the docket after he returns.
May it please the court. The second case for this afternoon is appeal number 123708 in the matter of Mitchel B. Christians, matter and attorney discipline. Your Honor, the disciplinary administrator has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Would you please state your appearances?
Madam Chief Justice Lukert and Justices, may it please the court, Julia Hart, Deputy Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
May it please the court, Chief Justice, the respondent Mitchel B. Christians appears pro se.
Thank you. Ms. Hart, you may begin with your argument.
Thank you. Good afternoon. I'd like to start with a brief recitation of the facts. I would note that this case was initiated based on a complaint submitted by the Kansas Court of Appeals through an attorney employee in February of 2019, after Mr. Christians failed to timely file a brief on a direct appeal of a defendant's 2 misdemeanor convictions of cruelty to animals. His failure to timely file a brief on the direct appeal resulted in the appeal being dismissed for his client. To go into those facts just briefly, in July of 2018, Mr. Christians timely filed a notice of appeal, but he failed to file a docketing statement. Several months after that July 18th date, or July 2018 date, in November of 2018, Mr. Christians filed a motion to file a docketing statement out of time and filed that docketing statement that same day. Less than a week later, the appellate court granted Mr. Christians' motion to file out of time. The deadline for him to file his brief was December 19th of 2018, and Mr. Christians did not file his brief by that time. On January 10th of 2019, the appellate court ordered Mr. Christians to file a brief on behalf of his client by January 29th of 2019 and notified him that it would not consider any extensions of time absent extreme circumstances. The respondent never filed the brief, and as a result, Mr. Christian's client's direct appeal was dismissed. During the course of the disciplinary investigation, Mr. Christian stated he had 3 email accounts. He did not regularly check these emails and was not aware that the appeal had been dismissed. He also stated his employees are responsible for putting dates on his calendar and notifying him of deadlines. A disciplinary hearing was held on November 5th, 2020. I would note at this hearing, Mr. Hazlitt appeared on behalf of the disciplinary administrator. Mr. Christians represented himself pro se. At the beginning of the hearing, the parties stipulated to the following rule violations: 1.1 competence, 1.3 diligence, 1.4 communication, and 5.3 responsibilities regarding non-lawyer assistance. At the conclusion of the hearing, the disciplinary panel that heard the matter found the respondent, Mr. Christians, to be in violations of these rules, which were stipulated. As far as recommendations at the disciplinary hearing, disciplinary administrator Stan Hazlitt recommended a 90-day suspension for Mr. Christians and that he be required to undergo a reinstatement hearing. Further, Mr. Hazlitt recommended that during this 90-day period of suspension, Mr. Christians do the following: that he work with KLAP, that he secure a practice supervisor approved by the disciplinary administrator, and that he develop a plan of probation. After hearing the recommendations from the parties, the hearing panel unanimously recommended the following as discipline: that Mr. Christian's law license be suspended for a period of 90 days. At the end of that suspension period, that Mr. Christians be subject to a reinstatement hearing pursuant to Supreme Court Rule 232. And at the reinstatement hearing, that he present a plan of supervised probation. Justices, I join in with the previous recommendations and am also asking that a 90-day suspension be imposed with the reinstatement hearing pursuant to Supreme Court Rule 232, where Mr. Christians presents a plan for probation. The factors that were considered both in Mr. Hazlitt's recommendation to the hearing panel and the hearing panel's unanimous recommendation and this deputy disciplinary administrator's recommendation are the following. First, looking at the ABA standards which guide us in this matter, Mr. Christians has committed multiple rule violations. His client was vulnerable and was injured by the fact that her direct appeal was dismissed. He has substantial experience practicing law and has been admitted to our bar for almost 37 years. I would note regarding one more aggravating factor, he does have several instances of prior discipline. In April of 1996, he was disciplined for violating Rule 1.4, communication with an informal admonition. In March of 1999, he was disciplined with an informal admonition. In April of 1999, he was placed on an 18-month probationary period for violating the following rules: 1.1 competence, 1.3 diligence, 1.4 communication, 1.15 safekeeping property, and 8.4 misconduct. In September of 2010, he was given an informal admonition based on violations of 1.1 competence and 1.3 diligence. And in August of 2017, he was issued another informal admonition based on competence, 1.1, 1.3 diligence, and 5.3 responsibilities regarding non-lawyer assistance. I would note regarding mitigation factors that were considered, Mr. Christian's actions in this case were not motivated by a dishonest motive. It appears that his physical health and mental health may have contributed to underlying conduct relating to these problems. I would note at the time of the hearing, and at this point, it doesn't seem like those problems have been addressed to assure that problems won't continue going forward. I would also note regarding some other concerns in considering what appropriate discipline is. The hearing panel noted in their final report that Mr. Christians has not taken steps to rectify problems which led to his misconduct. Specifically, his email inboxes continued to not be monitored and his case deadlines were not properly calendared. Additionally, during this disciplinary process, there were some red flags that are concerning that this deputy disciplinary administrator thinks that this 90-day suspension would be helpful in giving him a period of time to correct these issues. The formal complaint in this matter was filed on January 29th of 2020. Pursuant to Supreme Court Rule 215, Mr. Christians was to file an answer no later than 21 days after the service of the complaint. Mr. Christians filed his answer to the formal complaint on October 30th of 2020. I would note that's 10 months after the formal complaint was filed, and more importantly, it was 7 days before the evidentiary disciplinary hearing was held on the formal complaint. At the formal complaint, at the disciplinary hearing, in his closing argument, Mr. Christians acknowledged he had not resolved staffing issues that led to the missed deadlines and the dismissal of the direct appeal. And I would also note that procedurally, after the final hearing report came out, Mr. Christians filed with the appellate court a notice of exceptions with the final hearing report, but then failed to file a brief following up on that. Because he did not follow up with his notice of exceptions, everything in the final hearing report is deemed admitted by the respondent. For these reasons, we feel that a 90-day suspension is appropriate, and I'm happy to answer any questions.
As in terms of the probation plan, I assume that your recommendation would be that would address both the health or underlying health issues that contributed in addition to practice management issues. Yeah. Do you have any more detail, or is that just something to be sorted out at a reinstatement hearing under your recommendation?
I would note, Justice, while in my preparation for this argument, there were indications of congestive heart failure, depression, and substance abuse. Mr. Hazlitt noted in his allocution to the hearing panel that finding a supervising attorney would be helpful for him, that Mr. Christians getting involved with KLAP, both in setting up a law practice management plan through KLAP and addressing his health issues, both mental and physical, would be imperative to being successful on probation and to being reinstated, so that hopefully he does not appear before this court again.
I'm having trouble understanding the mechanics of the recommendation. I'm not pushing, I guess I am pushing back a little bit. It seems to me like you're describing someone who we ought to be concerned about allowing to continue practicing law until we get the supervision and those kind of things in place. And I can see that in the file. But when we're talking about a 90-day suspension, a reinstatement plan with a reinstatement hearing with a practice plan for probation. I mean, typically probation, we have something hanging over the attorney's head, like a 2-year suspension, and you let them come back. I'm just making these numbers up. I'm not suggesting, but a period of suspension, you would let the person apply 90 days into it. Then you get your probation plan, and then you have to successfully complete the probation plan during this period of time of suspension. And that's not what you're suggesting. You're suggesting a period of just reinstatement with practice plan for probation. And I don't understand how that works. I don't understand how Mr. Christian gets out of that. I don't, what's the measure of success with that kind of thing? And like I say, you're describing circumstances that make me worried about just letting someone back out on the street practicing law. And so how would you frame what you're suggesting, I guess is what I'm getting at. I know we got a 90-day suspension. We're going to go back to a reinstatement panel. But then what's that panel supposed to do other than approve a plan? But how, again, what's the rest of the story here? And then what happens? You see what I'm getting at?
I do, Justice Biles, and I appreciate your concerns, and I had similar concerns in preparing for this oral argument. I would note, backing up initially, when this investigation was conducted by the disciplinary administrator's office leading up to the formal complaint being filed, Mr. Christians was cooperative. He was forthright with what his issues were. He had a good attitude and accepted responsibility throughout the course of everything, and acknowledged that he did mess up. Again, at the disciplinary hearing, he again stipulated to the violations that were before the panel. And in his closing argument or statement, I would note Mr. Christians noted that even a 90-day suspension could potentially be financially crippling, was, I believe, what the words were that he used in describing that, and asked, it appears perhaps that he was asking for a plan of probation instead of suspension. But I would note that in speaking with Mr. Hazlitt in preparation for my argument and doing my own due diligence in preparation, it would be my thoughts that 90 days is a significant interruption to Mr. Christian's practice. And but yet it gives him sufficient time to get a plan in place to present to the panel. If he does have a sufficient plan of probation in place, you would look at Rule 232 of the Supreme Court rules for the reinstatement rules, or the guidelines that deal with that. And I would note that within those rules, if you look at condition H of Rule 232, it notes that if the Supreme Court grants a petition for reinstatement, it may order the attorney to comply with any condition or limitation on the attorney's practice The court may also order that the attorney's practice be supervised for a period of time. Looking at the probation rule, which is Supreme Court Rule 227, it sets forth not only what Mr. Christians would need to have in place for a plan, but it also lays out what happens if Mr. Christians violates his probation or fails to follow his plan. And if you look at subsection I and rule number 6 regarding the probation violation hearing, if a violation is found, the Supreme Court is not prevented from allowing a respondent to remain on probation or from imposing discipline greater or lesser than the board members or panel's recommendation. This would be a case where it wouldn't be an instance where Mr. Christians would be loose on the street unsupervised, or that there wouldn't be repercussions or tools or a vehicle for repercussion should he not follow probation. I would also note, in looking at Mr. Christian's prior discipline, back in 1999, Mr. Christians was placed on an 18-month probationary period, and he did successfully complete all the terms of that probation and was successfully discharged from probation. So it seems while Mr. Christians has been before the disciplinary board a number of times, that when he gets before the board, he does address his issues. And by having this period of suspension, we are acknowledging that not only this behavior continues and there needs to be a consequence for it, but that we want to help and make sure there's some sort of plan in place to put those training wheels on or put that added structure to Mr. Christian's practice to ensure that perhaps he will be successful going forward with his practice of law.
But the other side of that coin is that if we absolutely believe that supervision is required to allow the respondent to go back to practicing law, and that has to be under a supervision plan, and we suspend him for 90 days, and then we're going through the reinstatement process where it has to come back to this court, that 90-day suspension just got an awful lot longer. And for a sole practitioner, well, for any practicing lawyer, you know, that is a substantial blow to your practice, which is why I'm struggling with the 90 days and then the probation plan. I think the case is there for saying that we need supervision to permit further practice. But the way this is set up, it seems to me we're saying that 90-day suspension is going to be extended by potentially a long time. I mean, particularly if the hearing panel doesn't get it all put together, we could get that report toward the end of spring and then not have another court docket for a while over the summer. So I think we've got to work through those. You can think about this a little bit, but I think we have to work through the mechanics of how to make this sufficiently punitive, but not unnecessarily punitive, and still get the result we want, which is, getting Mr. Christian's practicing law in an appropriate way. So
just to follow up, because that was my concern also, Ms. Hart, is that where are we at right now with reinstatement hearings? There used to be 219 hearings. I guess there are 232 hearings now. Where do we stand? And are you proposing that hearing take place after the 90-day suspension?
Yes, Justice Rosen.
Okay, and so the question is follow up on Justice Biles is what kind of time period are we looking at? Because they rarely get done expeditiously, or at least within several months. It's usually a 3 to 6 month process.
Certainly. And what I would suggest to the court in my response is looking at Mr. Christian's history. He has been on probation once before. He is aware of what is needed to be considered to go on probation. In this instant case that we're before the court on right now, as I mentioned, the formal complaint was filed on January 29th of 2020. Mr. Christians was on notice from that date until November 5th of 2020. So an 11-month period almost, that if he was going to seek some sort of probation plan in his request for disposition, he would need to comply with the probation rule and come up with that plan. And looking at that 11-month period, he did not come up with a plan or present a plan to the hearing panel on that date to ask for that. Additionally, I would note.
Let me just say, you're not overly concerned about the extension of time beyond 90 days. It doesn't sound like.
I am not. The 90 days is the first date of which he would be able to seek reinstatement, and having this period of 90 days to concentrate on coming up with a plan without the distraction of a practice may be helpful in motivating Mr. Christians to spend time and energy coming up with a.
I think I more clearly understand your position. Thank you.
Thank you.
And
Justice
and I take it
Biles?
from that.
I'm so sorry, Chief Justice.
I had similar concerns to what Justice Biles and Justice Rosen have expressed. And so one thought I had is that sometimes the way this would work would be even longer suspension, but allow the respondent to apply to have some portion of that suspended to be placed on probation after a period of 90 days. And even though that sounds like and is a harsher punishment, sometimes the practical effect of it is that it really does allow someone to return to the practice of law at 90 days, rather than more like 6 months by the time you've worked your way through a reinstatement hearing. And so I guess what I would like to ask is if you see a problem, if there are reasons you think the court should not even consider some alternative like that.
Chief Justice, I think the court is certainly welcome to consider any and all plans that it would like. I think that when this recommendation was created, it was a way to acknowledge and recognize that Mr. Christians was being responsive, he was having the appropriate attitude, and just trying to give him a short suspension versus a year suspension or 2-year suspension, such as the court was talking about. I think that what the disciplinary administrator and perhaps the hearing panel may have been doing was trying to figure out what was the shortest suspension that could be done to get his attention and give him the ability to sit down and come up with a workable plan and then get back on probation. So as far as you potentially presenting this vehicle in a little bit different matter, it sounds like the end goal is the same in the way that you were proposing it as well. So I don't know that I see on its face any sort of disadvantage, but for he has that longer period of suspension than automatically hanging over his head.
Are there other questions? Or I think you maybe had something you were ready to add, and perhaps in response to a question.
Sure. I had just wanted to make sure and touch base with Justice Biles to make sure I had addressed his concern, because I know his question got hot potatoed along a couple different ways before I finished it.
He's not speaking up, so I think we can take that as maybe he's okay.
Thank you.
All right. Anything else then, Ms. Hart?
No, ma'am. Thank you.
Okay, thank you. Mr. Christians?
Thank you, Chief Justice. And I won't need all my time because obviously what has been stated already on the record did happen. There's just no doubt about that. And I've tried to be clear to the disciplinary administrator that it did happen. And I guess probably part of my not being aggressive in defending this is, again, just the whole idea of how do you, I mean, what happened happened. So whether we had this hearing by default or whether I appeared and stated my position, it was basically going to be the same. It doesn't change the facts of what happened. But what I can tell the court as far as what goes on here within my office is back in the spring of 2017, I had my youngest daughter take me to the ER because I hadn't been able to breathe at night for about 3-4 nights. And I thought it was maybe bronchitis or something. And that's when they, in fact, diagnosed the congestive heart failure. And my cardiologist, Dr. McKinsky at that time, said that based on what I had maybe a 50-50 chance to survive past 5 years. So unfortunately, of course, that then sets in kind of a mindset of, what does my future look like? I mean, how do I want to spend it if in 5 years I'm not here? Now, I can advise the panel that fortunately or unfortunately, it looks like I'm going to make it well past 5 years. I've taken serious exercise. I walk. My cardiologist has put me on a review for once every 6 months now. However, it's been kind of a psychological thing that I've just had to work through as to what my future does in fact look like. Now, unfortunately, with those health problems, it means that I have not been attending to my office the way I should have. I have readily admitted that. When I wasn't feeling well, I wouldn't make it in. 40-hour weeks were ancient history because I just couldn't maintain a 40-hour week. And so I've had to sit down with my shared staff to come up with procedures as to our going over the calendars twice a week, both physically, the physical calendars we maintain, and then on the computer. I've also set up a relationship with Stephen McConnell out at Central Kansas Foundation to talk to him once a week to deal with dependency issues. We've located a 12-step program at the Presbyterian Church here on 9th Street. I've tried to integrate a few things into my life so that even though at times it's unstable with the health issues, that I have people and resources out there that I can reach to try and keep it close to track. Now, again, I understand that this court will have to take some action to make sure that the public is kept safe from what I might do, and I appreciate that. And so, I guess from what I've just said, I don't have a whole lot more to add. What happened, and I'm happy to be alive. It looks like I'm going to be here a while, and so I'd like to be able to continue to help and assist the public, but it's going to be as you order that I should. That's all I have.
Are there any questions? Thank you, counsel. Ms. Hart, you reserve 3 minutes.
Based on Mr. Christian's argument, I don't have anything additional to add. Thank you, Chief Justice Lukert.
Thank you. Any other questions for Ms. Hart? Thank you to both counsel. We will then take this matter under advisement. Court is now adjourned.